Revocable and Irrevocable Trust, a Rookie's Guide. A living trust is a legal arrangement whereby you plan to pass on your estate, property, investments, and other assets to your family or other beneficiaries. It is an effective tool to plan ahead for the possibility of becoming mentally incapacitated or physically disabled so that the burdensome probate process can be avoided when the trust maker dies. All living trusts are either revocable or irrevocable and are established and activated while the trust maker is alive. The most significant difference between them involves who can manage the trust assets and whether the trust terms can be ever changed. Find out more. Welcome back, folks, to another edition of Sweetie Kiwi. How are you doing today? I hope you are doing fantastic. I'm doing marvelous, if you were to ask me. If you are doing as marvelous as I am, go grab a cup of coffee or tea or vodka and let's roll. Today, I want to talk to you about revocable and irrevocable trust. And I'm giving you a rookie's guide. The language will be very simple here. Now, quick heads up. A living trust is a legal agreement people often use to plan ahead for the possibility of becoming mentally incapacitated or physically disabled so that the burdensome probate process can be avoided when they die. So when you die, a living trust can act like a will, even replacing the need for one. One type of living trust can shelter assets from taxes, creditors, or legal problems. There are three major roles in a living trust. The trust maker, also referred to as the grantor, the trustor, or the settlor, the trustees, and one or more beneficiaries. So as I said, you have three major roles in a living trust: the trust maker, the trustees, and one or more beneficiaries. The trust maker transfers ownership of certain assets to a trust, and the trustee manages those assets for the benefit of the beneficiaries. Now, this is very important. I wanted to give that heads up so you understand what we're talking about when we're talking about living trust. You have to understand also you have to always keep in mind the trifecta: trust maker, trustee, and beneficiaries. Now, let's talk about revocable trusts. Maybe you're thinking about the next generations of your family, or you're getting older and you want some help managing your assets without giving up control. So setting up a revocable trust is a one estate planning option. In most cases, you as the trustor, as a trust maker, will also become a trustee and at least one of the beneficiaries with a revocable living trust. The trust is typically managed for your benefits, and you retain certain rights over the trust. You can name additional beneficiaries who will inherit from the trust after you die. If your goal is to provide continuity, if you become disabled or mentally incapacitated, you would name another trustee, sometimes called a successor trustee as well. This avoids the necessity of having a court name a conservator or guardian to take over the financial affairs when you become unable to manage yourself. You can also assign something called power of attorney to plan for the possibility that you'll be unable to manage your own affairs, but banks and brokers may have an easier time dealing with the trustee structure. Or even better, you can also you can also want your family to be able to help as you get older, or if you've got a progressing illness. You can retain the right to act alone while having a co-trustee help you too. Then if your health declines, the co-trustee can take over without disruption. Another common reason to establish a revocable trust is to avoid probate of your assets. If executed properly, a trust can negate the need for probate, the often arduous legal process used to determine if a will is valid. If this is your goal, make sure to weigh the expected cost of probate against the cost of hassle of establishing a trust. With a trust, you must re-register your property and securities in the name of the trust, and probate can be very involved, particularly if you own real estate in more than one state, but it may not be. In addition, you can prevent the details of your estate from becoming available to the public if you use a revocable living trust to manage your estate plan. Now, let's talk about the duties and responsibilities of guardians and conservators. A guardian or conservator is appointed by the court when an individual has been determined to be mentally or physically incapacitated, or when a minor needs an adult to manage their property and assets. Those in need of such care are referred to as wards of the court. Wards of the court, WARDS. The duties of guardians and conservators can overlap, and sometimes the same person can be appointed to both roles, but they're very different. Let's talk about guardian responsibilities. A guardian is responsible for an elder or a minor ward's personal care, providing them with a place to live and with ensuring their medical needs are met. Guardians make sure that their ward has a place to live, such as the guardian's home with a caretaker or in an assisted living or a full care facility. Minor financial responsibilities, such as paying bills, purchasing daily necessities, are also a guardian's task. Guardians are also required to make sure minor wards are receiving the education they require in addition to the formally listed duties, and for receiving any training that the ward might require. A guardian can often make medical decisions on behalf of the ward, although some states limit this power depending on the status of the ward. So generally, the guideline of income or benefits of $24,000 per year is used to establish whether a person needs a guardian or a conservator. Conservators are used when wards have more financial holdings. So let's talk about conservator responsibilities here. Conservators are appointed for those that need having their financial affairs handled. In other words, people who are rich. In cases where wards have more substantial holdings, the conservator becomes responsible for determining whether assets such as real estate and tangible property, personal property that is, should be bought, held, or sold. The conservator will maintain ongoing contact with the ward's financial institutions to ensure that everything is running smoothly and being dealt with appropriately. So the order of conservatorship provided by the court gives the conservator the legal power to make financial decisions on the ward's behalf. So as you can see, the conservator has more power from a legal perspective than does the guardian. Celebrities that reach popularity while young tend to have some issues once they're able to access their own finances. So it is not uncommon in that case for a court to appoint a conservator to manage the young celebrity's affairs. In rare cases, conservatorships can last much longer than state laws mandate, generally 18 or 21 years of age. The conservator here uses the ward's finances to pay the bills, including medical and personal bills. They also make sure income taxes are filed and paid as needed. If the ward has liquid assets able to be converted to cash quickly, a conservator can decide whether the funds could be held and who will be responsible for overseeing their investments. The conservator might do this themselves or enlist the help of a professional financial advisor. This is for the first part. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Q. We are having a tutorial here around revocable and irrevocable trust. If you love this content, if you love the clarity and quality of the content so far, please consider subscribing to our channel and turn on the notification bell so you know the next time we drop a new show, you can be informed ASAP. And also like this content, share, and comment below if you have questions or you just want to share your experience with us. Now, we want to continue to talk about conservatorship. This is very important, and I want to talk to you about conservator accounting. A conservator is usually responsible for preparing an accounting of actions they have taken on the ward's behalf, and they have to file with the court each year. Remember, they are appointed by the court. So some states require that a conservatorship must begin with a full accounting of the ward's assets and debts at the time the conservatorship is established. In other words, the court wants to see a beginning balance sheet. The annual accounting typically includes how the ward's assets have been bought, sold, or invested, and what has been spent on behalf of the ward during the previous year. A doctor's report might be required, detailing the ward's current mental and physical conditions, and can state whether a guardianship or conservatorship is still required. The accounting should include a plan detailing the medical treatment and personal care received by the incapacitated ward in the previous year, as well as an outline of the plan for the ward's medical or personal care for the next year. So a court-appointed guardian or conservator must also typically file a final accounting of a minor's asset when the minor reaches adulthood. Now, sometimes we need to understand when court approval is required. Guardians and conservators have many duties and responsibilities when given a ward to look after. As I said earlier, they're called ward of the court. Depending upon the laws of the states where the ward lives, some of those duties and responsibilities will require court approval, while others may not. For example, Florida. Florida law requires that a conservator must get court approval before selling any of the ward's real estate or personal property. Nebraska, on the other hand, requires court approval before using the ward's debit card for withdrawing funds from an account. In Massachusetts, a guardian cannot admit the ward to a long-term care facility or administer certain drugs without a special court order. So if you have been granted the privilege of caring for someone as a guardian or a conservator, make sure to familiarize yourself with your state's laws and requirements. Now, if you have been asked to serve as a guardian or conservator, there are a few things you need to know. A guardian or conservator is considered to be a fiduciary. In other words, someone who is legally bound to put the ward's best interest before their own. This can be very time responsibility, so you'll need to be sure you have the time, resources, and patience to put into them. So I've been talking to you about revocable trust. Let's now talk about irrevocable trust. An irrevocable trust, I'll get it. Irrevocable trusts are usually used to move assets out of your name and control for the purpose of eventually being transferred to the next generation. This also reduces the value of your estate for estate tax purposes and provides protection from creditors and lawsuits. Irrevocable trusts also have been used to help with Medicaid eligibility because they avoid the necessity of spending down assets. You've already transferred your assets into the trust, ideally well outside of the look-back period. We'll talk about the look-back period in another show. It's a very interesting concept. You typically shouldn't serve as a trustee when you form an irrevocable trust, nor can you take your property back after you transfer it into an irrevocable trust. You cannot undo or dissolve such a trust either. Unlike with a revocable trust, where you reserve the right to dissolve or change the trust at any time, as long as you are mentally competent, an irrevocable trust is, for the most part, forever. That's hence the term irrevocable. Now, let's talk about estate taxes. Property that you've transferred into an irrevocable living trust does not contribute to the value of your estate for estate tax purposes. Just as your creditors and judgment holders cannot reach it, neither can the Internal Revenue Service tax your estate on its value. This can be very beneficial if you have a very large estate. Estates valued at more than $11,400,000 in 2019 and $11,580,000 in 2020 are subject to a federal estate tax on the balance of their values over this threshold. Now, this threshold, called an exemption, is needed for inflation, so it goes up annually, but it might not always be this significant. The exemption increased from $5.49 million in 2017 to $11.18 million in 2018 under the terms of the Tax Cut and Jobs Act, the TCJA. And you have to understand, the TCJA is not necessarily permanent. It sunsets or expires at the end of 2025, and the exemption can be expected to plummet back into the $5 million to $6 million range at the time if Congress doesn't renew the legislation. Now let's talk about government benefits when you have an irrevocable trust. Assets that you or a beneficiary own can count against you for purposes of qualifying for certain government benefits, including Medicare, Medicaid, and supplemental security income. Transferring assets out of your ownership can avoid the necessity of depleting your property to qualify for assistance in paying for nursing home. You have already given the property away when you funded your trust. As long as you don't need long-term care within 5 years of the transfer, that property does not count against you for purchases of qualifying for assistance. An irrevocable trust can also protect assets for special needs beneficiaries when it's designed in such a way as to avoid disqualifying her or him for crucial government benefits, which can be the case if he or she inherits assets outright. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Keyword. We're also here talking about revocable and irrevocable trust, and I'm giving you a rookie's guide. Who should act as a trustee? If you remember, I said that when you have a living trust arrangement, you have three parties, right? You have the trustor, the trust maker, the trustee, and the beneficiary. Now, who should act as trustee? One of the most specific differences between revocable and irrevocable trust concerns who acts as trustee or successor trustee. When spouses form a revocable trust together, when spouses form a revocable trust together, they are typically each trustee. So one is a trustee and the other is a successor trustee. In an irrevocable trust, naming yourself as a trustee defeats the purpose if your goal is to protect your assets from creditors and other financial requirements. State laws generally don't dictate who can or cannot act as trustee or successor trustee, and the terms of the trust document typically dictate what the trustee can or cannot do. But the decision should be addressed thoughtfully. Here are some qualities to consider. You want the trustee to be someone you trust to manage your investment well and hopefully not lose money. They must be able to deal with beneficiaries, often on an ongoing basis, which can require tact and diplomacy. When the time comes, they must understand how to legally transfer trust assets to these beneficiaries. They should know how to handle sometimes complex financial transactions and have at least a basic knowledge of state law. Some people use a corporate trustee, and some name family members to this role, particularly as successor trustees. This situation can present a variety of problems here. Why? Let me give you an example. Naming, say, one son or daughter over another can create friction and imply a sense of favoritism. You are effectively trusting this person to put all personal feelings aside when dealing with your beneficiaries, many of whom are probably also family members. Many who establish irrevocable trust appoints professional trustees for this reason, either a trust attorney, an investment firm, or a bank. While this takes personality and emotions out of the equation, keep in mind these entities don't work for free, so their service will cost you your trust money that would otherwise have been passed on to your beneficiaries. A halfway measure might involve naming multiple co-trustees and requiring their unanimous agreements on any actions taken. It would not necessarily cut down on emotional friction, but you can at least be assured that decisions are balanced. Another thing you might want to do is you may want to consider naming a family friend or business associate and leaving your offspring and other family members out of any management roles. Now let's talk about special types of living trusts. Trust can be designed to meet specific purposes and concerns, right? I've already talked about it here. You have an irrevocable life insurance trust. This holds only an insurance policy on the trust maker's life. The policy is owned by the trust, so its proceeds are not generally included in the gross value of the decedent's estates for estate tax purposes. A special needs trust can be set up to provide for a disabled beneficiary in such a way that it doesn't compromise their entitlement to supplemental security or Medicare benefits. A spendthrift trust creates a platform or a process whereby it gives the trustee discretion as to how and when distributions should be made to a beneficiary who is not financially responsible, or to safeguard the inheritance in the event the beneficiary divorces. All right, so irrevocable life insurance trust, ILIT, special needs trust, and spendthrift trust. All right, folks. This is it for today. I really appreciate your attention. I hope you enjoyed the value of this content. And here is a recap of today's conversation. So I spoke about revocable trust, irrevocable trust, who should act as trustee, and special types of living trust. I will see you another time. But until then, remember, stay marvelous.